not lawyers. We don't. Well, the Black's law dictionary is good value. Is it still valid as this book?
Yeah. Okay. Proprio jure, Latin for by one's own property right. And what was the other one, Peter?
It's on the big screen up there, proprio motu, but it's in the International Criminal Court Statute of Australia.
This is on the whereabouts?
Proprio motu. No, what's up there? Hang on. Yeah, just above the 13th. Prosecutor may initiate investigations proprio motu on the basis of information on crimes within the jurisdiction of the court.
Right.
That's in Black's law.
And
Is that the dictionary? No.
okay. So we're outside of our common law jurisdiction under capitis diminutio. Okay, so when we reply to them, then we would try to make them understand that that's a foreign individual that you're referring to. Now, for those who may be interested, just while we're on that subject, I've got some flyers there for a seminar that is being conducted by one Mr. David Wynne Miller. He will be here in Melbourne on the Sunday, the 8th of August. This gentleman, yeah, he's got an IQ of over 200, this guy. We've sat and talked with him. He's absolutely staggering. Yeah, he said he's a Freemason to keep the enemy close. He is he's pretty much the world leader on syntax. We all aware of what syntax is? Yeah, it's sentence structure. Now, if you go to AustLe, the legal site for our laws, you'll notice that on the High Court registration with respect to any court cases 1903 forward, it will have in syntax. Okay, so this guy has sat down and worked out the syntax and worked out where the system have manipulated our laws with regard to proper sentence structure and putting the law that our people have laid down in the non-truth rather than the truth. Okay, gentleman there.
This move away from the Constitution and this push for privatisation, is it in the end just to make more profit?
The thing is, what you've got to be aware of is under section 118 of your Commonwealth Constitution, full faith and credit has to be given to all public acts and judicial proceedings throughout the Commonwealth, right? So we can go back to 1215 under section 118. Now, in 1550, there was an act brought in called the Public Officers Act, and in 1809 it was called the Sale of Public Offices. It strictly forbids the sale of any public office.
They collected $3 million the other day, Moorabool Shire Council, out of public land.
That's right. They cannot sell any public office, like we've been confronted with today with respect to our public transport and the private owner of that public transport. That is forbidden under the law. Now, the last conviction under the Sale of Offices Act 1809 was in 1864, and it was against a officer of the Navy for trying to sell his office. He got a 2-year jail term for breaching that law. And that was the last time it was used, but it is still in force. Now, the New South Wales government in 1975 proposed to amend that act. But the New South Wales Law Reform Commission clearly stated that it is beyond the power of any legislator in this country, federal or state, to amend or repeal any imperial law. It comes under the heading of the imperial laws. Section 118 of our Constitution is crucial. It is a foundation pin that is self-supporting. We must understand Section 118, drive it in here, imprint it. Full faith and credit to all public acts, all the laws of England. Again and again, High Court have said over the last 100 years, the laws of England are part and parcel of the law-making ability in this country. They must be adhered to. It's only we the people can get rid of that. Okay?
Does that throw all the acts after 1986? Does that knock them out?
No. Okay. To show you why the Australia Act's a joke, no act, Section 1 of the Australia Act. No act of the Parliament of the United Kingdom passed after the commencement of this Act shall extend or be deemed to extend to the Commonwealth, to a state or to a territory as part of the law of the Commonwealth, of the state, of the territory. I mean, it's ridiculous.
So we got the country run by criminals.
No, a cartel. I'd say a cartel.
Well, we get our guns back, we'll be right.
No, the pen's mightier than the sword. Pen's mightier.
Sounds like, isn't it? Or do we all run to the UN like Kevin Rudd?
No. Keep.
If the Queen took an oath when she was crowned at coronation, saying she would protect our laws and customs, why did she remain silent when our 1984 referendum clearly said that we don't want to give it powers to the states? Why did she remain silent when the law in Australia came in?
I would, from what I've studied, the 1984 referendum was one of those referendums that just slipped by. We all voted in it, slipped by, and then it was forgotten about because there are Queen's Councils in London who tried to challenge the Australia Act when it was implemented, and they didn't even know that there was a referendum in 1984. No. The Governor-General, under Section 128, it's the Governor-General who then passes to both Houses of Parliament the proposed question, and then it's up to those two houses to adjust the questions put in the referendum to the people accordingly. But that's it.
The oath she took it when she was crowned says she's there to protect our laws and customs, so she must, doesn't mean she must actively make sure our laws are not tampered with?
Well, with respect, Section 58 does put an obligation on her with respect to the Governor-General, and if there's any questions to be raised, then yes, it must.